So thank you very much for joining today to this sixth edition of our Certi-Trust Trust Talk. We're just going to wait a couple more minutes just to wait for everyone to join, and then we will start with this Trust Talk. Okay, so I think that we can start. So thank you again, everyone, for joining today for this sixth edition of Certi-Trust Trust Talk. Today's topic is quite interesting. Today we're going to talk about this question that has raised in the last years on whether or not it's possible to have privacy without security, and what's the interconnection between both of them, and to see and to, let's say, try to better understand what are the ins and outs of these two topics, which seemingly go always together, but which can pose quite some threats sometimes, or even some challenges to tackle both of them. Just as a reminder before we start, and let's say going quite in line with the topic of today's webinar, this full session is going to be recorded. So just to make sure that everyone is well aware of this. And at the end of the day, once the session is finished, we are going to post it on our YouTube channel so that everyone is able to see it again if so desired. Just before going into the topic itself, I would just like to present myself. So I'm Pierre. I will be the moderator for this session, as well as to present both of our panelists, which I'm very honored to be able to introduce. So first of all, we have Mueni, who is the head of projects and information security consultant at Sentinel Africa. So thank you very much for joining today, and who will present her topic, which is called well, the presentation, or let's say her word of advice, if you would, even, which is called "If There Can Be No Privacy Without Security," and we'll see, let's say, how she can enlighten us with her wisdom and her expertise. Later, we'll be hearing Pierre, who is the CEO of our Certi-Trust, as well, let's say, active in the field for the last more than 20 years, I would say, with whom I've been able to work quite a lot since the last 5 years. And I'm sure that he will be able to present us with his topic, as well, this dichotomy as well, on which is called privacy versus security, and he will be able as well to show us and to present this, let's say, this question that is raising more and more each day. With this said, I think that we can go ahead and to start with the presentations. Just beforehand, to let you know that all questions that you may have during the presentation will be answered at the end of both presentations. So we'll have some time at the end to answer all your questions, or at least as many as possible. If you so desire to raise any questions, feel free at any moment during the presentation just to click on this question and answer button on Zoom. Just type down your question, and at the end of the presentation of both of them, I will just present them to our panelists, who will be answering them as well as possible. So with further ado, I would like to, let's say, to receive Mueni, and to thank her again for participating here, and to, let's say, I will give you a hand so you can take over whenever you so desire. Thank you very much, Faith.
Great. Thank you very much, Kieran. Good evening and also good afternoon, everybody, depending on where you're joining from. Thank you so much for making time for this. Indeed, such a pleasure to see all of you. So I'm just going to share my screen so that we can go right into it. Great. I hope you all can see my screen.
Yeah, perfect.
Yeah?
Yes.
Great. All right. So basically, the webinar today is titled "There Can Be No Privacy Without Security." And this, as you might already know, is indeed a topic that is very popular currently because of the recent or not so recent focus and regulations around data protection and also privacy. Yeah. And so it all started way back in 2018 with the GDPR. And then thereafter, then we had other continents, other countries all over the world follow suit and also start looking at how to implement local regulations around data protection and privacy. But then even as the regulations become more stringent, as they become adopted and implemented, the best way to approach data privacy has been something that is sort of a contentious issue, right? Because then on the one hand, you realize that there is an assumption that because I have an information security framework, then my data is protected, right? And so there is an assumption that by virtue of having an information security framework, then indeed you have automatically achieved data privacy, right? And then also the other thing is another assumption or wrong approach of organizations wanting to go right ahead into looking at how best to just comply with the regulations clause by clause, only to realize it all leads back to the basis, which is information security. So the point really of this webinar at the end of the day is going to be that for you to achieve data protection, for you to achieve adequate privacy of personally identifiable information of the data subjects that you are in charged with, you really need information security. So information security is a prerequisite for data privacy. Okay, so now, first, just to demystify these two things, we have security, which security is essentially concerned with protection of confidentiality, integrity, and availability of information. So confidentiality is ensuring that information in its shape, form, whether it's physical, in paper, stored in a cabinet, sitting on a cloud server in Germany, or also sitting in your data center, right? Information is accessed only by the persons that have been granted access to that information, yeah? Only by the authorized people. And then when it comes to integrity, here you're concerned with the fact that information where it is stored can only be modified by the people who've been authorized to modify it within the authorized parameters. And then lastly, availability is concerned with ensuring that if I left my data locked in a cabinet, I expect to find it there tomorrow. If I did my last backup onto my Azure cloud server yesterday at 12 p.m., I expect that when I check tomorrow, that information is going indeed to be there. So availability is concerned with ensuring that information is indeed available. And so security looks at those three core tenets. That is the CIA triad, yeah? Confidentiality, integrity, and availability. Now, on the other hand, privacy is concerned with fine. So I am your customer. You have my details. You needed my details for you to process or to give me the services that you offer or you're granting. Say, for example, it's a bank, right? So you have my name, you have my ID, you have my age, you have my religious status, my marital status, my physical address, and so on and so forth. Now, the first thing privacy is concerned with is how are you collecting this information? Are you collecting it in a rightful manner? Are you ensuring that the information that you have about me is actually the information that I gave you? The other thing is in terms of how an organization goes on to process or use this information, whether they disclose it to their HR departments, if I'm a staffer at Sentinel Africa, for example, right? If they disclose my information is with HR for processing of payroll, or for a bank, they have to disclose this information to a third-party payment service provider, right? So this is some form of disclosing my personal information to a third party whom I did not give information. And so what are the parameters around this? The other thing is in terms of data quality. Like, I do not expect to find that in your records, I see it as Mr. Faith Mueni, because that is misrepresentation. I'm Miss Faith Mueni. So that is basically what I would expect. Or if I'm Faith, right, I would expect to find my names in full in terms of like, I'm Faith Mueni, not Faith Muende, or something of that confusion. And then the other thing also that has been introduced by data protection regulations is around also how can I easily access my information? If I want to just confirm the kind of information you have about me, if my marital status changes and then I change my name, if I move places, then I want to see, is that information accurate so that I can be able to update it where necessary, or delete it if at all I don't want you to have access to my information anymore. So you find that privacy is concerned with the kind of personally identifiable information that you have and how you use it, how you disclose it. And that, in as much as it is concerned with security, these two things are not, they are completely not the same thing, yeah? However, for you to achieve protection of personal information, yeah, for you to achieve privacy, you need security. Why? Because information from a privacy perspective can be accurate in terms of the data, in terms of the bank creating a portal where I can access my PII whenever I need to access it. It can be indeed accurate. But then if this particular portal where I'm accessing the data from is not encrypted, yeah, so this means that the portal can be accessed by pretty much anybody who has an open source pen testing platform, then that means that this information can be accessed, yeah, can be accessed by people not authorized to access it. And then that will eventually lead to an authorized disclosure of my PII. And so you find that at the center of achieving data protection, then security plays a very big role in ensuring that information has to sit in a manner that even if there is accidental disclosure, for example, there is successful hacking of this portal, then the information is, say, for example, masked. Yeah, so we have pseudonymization of this information to ensure that even the fields are only visible to people who are authorized to view this particular data. And so just to show some more context into the current environment. We have had, as mentioned already, the GDPR coming into play in 2018. And since then, organizations all over the world going on to actually implement different regulations that affect their local context. Yeah, in Kenya we have the Data Protection Act, and in fact, actually, in East Africa, we've seen tremendous growth, which was, quite a surprise to see that, indeed, even Uganda as well as Rwanda already have these laws in place. They've been assented to, and compliance has already begun. Yeah. And also, when you look at the stats from a global privacy, from a global perspective, you can see that indeed, and especially where we have heavy regulation, and where regulation is not very heavy, at least you can see that there is some moderate activity going on. And so this means that probably these data protection laws are still in review, yeah, prior to being assented to and approved for them to become actually laws that you actually are supposed to comply with. The other thing that we are also seeing is that for different countries as well, the approach is different. And so you find that there is a key focus on, say, for example, a specific functionality around data privacy. So say, for example, a particular regulation on how exactly I withdraw my information, if at all I do not want for any organization to have access to it. So how do I go ahead and withdraw my information? After all is said and done, I think it is clear to see that indeed this is something that has, it's already in place. There is a lot of improvement, a lot of activity going on around adoption and implementation of data privacy regulations across the world. And so then the question begs, how then do you go on to achieve data privacy? Yeah, because you've already said it is closely married to information security. Then how do I go ahead to achieve said privacy? So here, key things that you want to worry about. Number one is in terms of data security. Yeah, so if at all information is going to be accessed, is it actually being accessed by the people who are supposed to be accessing it? Again, going back to confidentiality, right? And so this, and especially just to paint a context, is where you find that an organization will say that in the information PII that is being collected is stored on a database. Oracle database for that matter, right, has robust security controls. Access is restricted only to admins, and the kind of access they have also is limited only on a need-to-know basis. You find that there is database activity monitoring solutions. So activity around these databases, who are accessing the information, at what time are they authorized to access it. There is continual monitoring of this particular information. But then again, you find that if this information is sitting in plain text, if it is sitting in plain text, it has not been encrypted on the database, especially where there's no masking of information that is not necessary to be seen, like card numbers or account numbers, right? Then it essentially just leads back to the fact that we do not have sufficient controls around who is accessing this information and are they actually allowed to access it. So then again leads to the second point in terms of access control. What are the parameters around how we identify and authorize persons to access information? So identification is one thing. I can know that the username is Faith Mueni, right? But then the password and then the OTP or the the other code that I received to be able to indeed be authorized to access information. Then what are the robust controls around that? And then lastly, how do you ensure that data is protected? And now this leads back to those controls that we've been talking about around encryption of data, masking where it's not necessary for data to sit in plain text, having implementation of information security controls like an antivirus, right? To ensure that if at all there is unauthorized access to an endpoint, then this access does not lead to compromise of our critical assets where PII is stored. So in terms of how you go then ahead to implement a data protection framework, so the first thing is, of course, in terms of awareness and communication. So the first thing is to understand from all layers in the organization, what kind of PII do we have in place? How are we collecting it? Is it in line with the relevant data protection regulations, right? Also, where the PII is sitting, first, you can't protect what you don't know. So that now means that you have to identify your assets. What are your assets? What are we exactly trying to achieve, right? We just want to ensure that PII is must, it is accessed only by the persons who need to have access to it, and that we are complying with the regulations. And so it is important for the different layers in the organization to understand what role they play towards data protection. So from a strategic perspective, it is of course to ensure compliance, right? Because lack of compliance has reputational damage, it has reputational impact, could lead to withdrawal, leads to fines and also withdrawal of your operating licenses. From tactical and also operational layer is to ensure that the relevant framework for how we protect PII has been implemented. And from an operational perspective, it is practiced on a daily basis, not documented and implemented, but then circumvented by humans, but rather it is actually practiced. Then the second thing is conducting a compliance assessment. So of course, just knowing this is the expectation of, say, for example, the Data Protection Act in our country, right? And then on the other hand, then where are we? So, and what are the gaps? Once you know where the gaps are, then it becomes easy to have a compliance roadmap, a roadmap towards achieving compliance. Again, the key thing to note here is that compliance is not achieved overnight. It's something that you work towards with time. And so once you have a gap, picture, then you can be able to plan, what am I going to achieve in the short term, medium term, and long term. And then the third thing is, of course, to come up with a data protection framework. This framework will, of course, consist of policies, technologies, and processes, as well as the necessary people to ensure we achieve data protection. And key thing to note is that before you get to privacy, you have to look at your security. And even when you look at standards around implementation of privacy controls, such as ISO 27701, that is the standard for implementation of a privacy information management system, still does not ignore the controls around information security, still keen on controls around information security. The fourth thing is to implement protection of data control. How do we collect data? Are we ensuring that we are getting consent from our customers? And then also, do we ensure that whatever we preach in terms of protection of data is actually what is implemented? Ensuring customer consent processes, again, data breaches, identification and notification, because this is something that is very key to ensure that every time there is a breach, you report it in time to the relevant office, and also show in terms of what are the measures we've put in place to ensure that the situation has been contained. Failure to which, again, could lead to fines. Then the other thing is to conduct a data protection impact assessment, just to know your risk exposure areas, the level of risk you're exposed to, and then also to, again, work up a roadmap towards achieving compliance. And then last but not least is to ensure that you have someone in the organization who is concerned with protection of information. And in this case, they are normally referred to as a DPO. And so the DPO, essentially their work is to ensure that number one, more than anything, they have the right professional qualities, but then over and above that, they need to have an understanding of the local context and the relevant laws around regulation in their country. Also the GDPR, other relevant laws that have been implemented in other countries, because and especially where you have cross-border customers. And also last but not least, organizational technology and processes and assets, right? Because this person needs to know, they need to understand the entire risk landscape insofar as data protection is concerned. And so they need to have a very sound understanding of the environment that they are working in, the kind of technologies we have, and where PII is sitting, so that they can devise adequate and suitable frameworks for protection of data. And then last but not least, also, they need to be able to fulfill the DPO tasks, and these are the DPO tasks, yeah? They need to be able to map out the associated risks around data protection, to ensure that there is continued compliance with regulation. So you find that regulation, again, as already mentioned, it's compliance, it's a continual and it's a journey that you walk through. And so again, to ensure that we continue to comply, whenever there are technology changes, there are changes into the regulations, changes that stem from customers and the market, yeah, again, to ensure there is continued compliance. Also to ensure that there is communication where necessary with the relevant stakeholders insofar as data privacy is concerned, and also to ensure that every employee in the organization actually understands, what the role they play, where we are at, what exactly it means when there is intentional or accidental exposure of PII, what it could mean to the company, and then how then do you ensure that you're playing your role to ensure that you're continuing to comply. And then last but not least, of course, they are the subject matter experts insofar as data protection in their organization is concerned. Okay, so that's it. Brings me to the end of my presentation.
Thank you very much, Faith, for this very interesting presentation. Again, if you have any questions during this presentation or the next one, feel free to write them down on the question and answers tab on Zoom, and at the end of the presentation of both of them, we'll proceed to answer them as many as possible. Thank you again, Faith. So without further ado, I will let Pierre do the, let's say, start with his presentation. If you're ready, Pierre, I give your hand. Yeah, it's good now.
Good. Here it is.
Perfect.
Can you see?
Yeah.
Perfect. Hello, everybody. My name is Pierre. So as Karen introduced me, I'm the, let's say, the person busy with those, let's say, legal matters in Certi-Trust, and we'll try to do today some kind of an explanation about what's the real trade-off between security and privacy, privacy and security. Is it an impossible trade-off, or is it not? Then to start with the the short presentation I was supposed to explain, let's say that we will start by talking about the origin of this trade-off that was necessary between privacy and security, and especially in the Charter of Fundamental Rights. We will then talk a bit about privacy protection in general, talking also about some framework could help to reconcile potentially security and privacy together. Challenges faced by privacy protection matters, challenges and threats, the question of big data, because it is somewhat the topic is very undermined by the question of data collection, data storage, limitation of data, of course, and Faith presented just beforehand some aspect in terms of, let's say, respecting regulation and being kind of, let's say, cautious with those type of elements, thinking about data mining, security of information systems, a little word about also the personal data life cycle, which means that inside some security framework, we will be able also to take into consideration the protection of personal data related to privacy of subjects. A topic about privacy by design and default, and then we will come to the security measures that it will be already the end of the journey that we will have done together. So let's start by there. Whereas, let's say, privacy concerns mainly the protection of one's information, it should be considered that it is mainly about identity management and being in control of our online profile. And security relates more to a person's awareness of all online action and behavior can be put both at risk in that matter. Privacy and security domain covers basically competences such as, let's say, effectively managing information shared online, using tools, let's say navigation filters, passwords, antivirus, firewall software, to name some of them, to avoid basically dangerous or unpleasant situation or to retain some sense of anonymity. And protecting privacy online calls on a broad spectrum of competences. Basically, the very meaning of privacy is basically underpinned by knowledge and the critical understanding of self and others, and value for human dignity and human rights. This is not possible without a solid knowledge of how today powerful communication tools work, a critical understanding of the many ways that information can be used against us, and how snippets of information or tagged photos, for instance, can easily be put together to complete a far more detailed and possibly sensitive picture than was initially intended. Privacy is a culturally sensitive concept that calls for a solid understanding of cultural diversity, and therefore respect for the beliefs, worldview, and practices of others, and the motivation, especially to protect such personal information from being spread across the internet. Then let's come to some basics. The Charter of Fundamental Rights, especially in the chapter 2 about freedoms, and distinguishingly Article 7 and Article 8, respect for private and family life and protection of personal data, are all bringing together the fundamental rights of everyone living in the European Union. It was introduced to bring consistency and clarity to the rights established at different times and in different ways in individual EU member states. And basically, that charter, which is directly, let's say, related also to the human rights Charter of the United Nations, basically, sets out the full range of civil, political, economic, and social rights based on fundamental rights and freedoms recognized by the European Convention on Human Rights, the constitutional traditions of each of the EU member states, for example, long-standing protection of rights, which exist in the common law and constitutional law of the EU member states, the Council of Europe's Social Charter, the Community Charter of Fundamental Social Rights of Workers, and other international conventions to which the EU or its member states are parties. Basically, sorry, I was just a bit quick on the trigger. Basically, we can consider, if we would take, let's say, a larger view on what is the state of privacy protection legislation around the world. You can see by this chart, which is taken from UNCTAD, which is very recent because of December 2021, that the topic has been, let's say, embraced by a lot of those states around the world, and 71% of those countries have now a legislation. 9% of them, of the 100, of course, have established some draft legislation, still ongoing, but which will lead at some point to a good 80% of all countries having, let's say, embraced the topic. 15% remains with no legislation, and 5% countries we don't have specific data about them, which most likely means that they won't have something, let's say, very actual to deal with. But as more and more social and economic activities take place online, the importance of privacy and data protection is increasingly recognized. Of equal concern is the collection, use, sharing of personal information to third parties without notice or consent of consumers. 137 out of 194 countries had then already put in place legislation to secure, to somewhat extent, the protection of data and privacy. Africa and Asia show different level of adoption, with respectively 61 and 57% of countries having adopted such legislation, and the share in the least developed countries is only 48%. Let's look at a, let's say, synthetic table to get more hints about it. You see that basically out of the different regions around the world, one drive at the moment really much let's say the campaign about, I would say the campaign about data and privacy, personal data and data privacy protection. In Europe, 44 countries out of 45 have actually developed a legislation about data protection under the umbrella of the GDPR, of course, but anyway, it makes Europe, let's say, the center of this concern for the major part. Then we can see that there are also some interesting figures we could see. This is Africa, for instance, has developed a lot of different initiatives, and we have basically a very good number, like almost 2/3 of the 54 countries referenced in Africa are actually managing a legislation around data protection and privacy. 6 have got draft legislation, which means that at the very end, we will have more than 70% of them being covered, which drives more or less this to the same level as the American continent. 10 of them remains without legislation for different reasons. Basically, there is also a bias in that presentation because least developed countries are also part to somewhat Africa, Asia Pacific, or South America, so we have kind of a little overlap in there. But anyhow, it shows that basically the evolution of the privacy protection legislation has been, let's say, very much followed up by the different institutions, different countries, different states for the last 10 years. Basically, if we start let's say thinking further about the how this concern about privacy protection can also meet the concern of security, there are of course different answers. They can be provided and brought by the different states regarding the link and the balance they establish between privacy and security. It's not only a matter of being or keeping private, but it's also a matter of keeping efficient in managing privacy inside a corpus of different information system, digital system, with different level of security. And how can security bring also let's say, can leverage some benefits to keeping private while keeping secure is also very interesting. This is why I'd like to share with you a European framework that has been developed in 2015, which is called PRISMS, P-R-I-S-M-S, which is a framework for integrated decision-making about privacy and security. This framework analyzed basically the traditional trade-off model between privacy and security, because they often suppose relationship between security and privacy in terms of a trade-off poses, let's say, I would say internally, an intellectual and a policy challenge. Is it possible to empirically contest existing ideas which have dominated national and European policymaking for too long, that having more security leads to less privacy? This is typically what this project has tried to deal with. And on top of analyzing this trade-off, it devised a more evidence-based perspective for reconciling privacy and security trust and concern by analyzing security and privacy technologies, by doing a thorough assessment of policies for both security and privacy, adding a layer of criminological analysis, putting a legal perspective in place, attracting media attention to privacy, security, and trust issues, and setting the analysis of existing public opinion surveys. I set the link that we will share later on the YouTube channel and the different other platform, but the link to the project is mentioned in the presentation, and I invite you to give a look and to look further about how finally this trade-off can be managed adequately thanks to such a framework. So a little tool that I share with you. Of course, John Poindexter told him really well. He told us, I really believe that we don't have to make a trade-off between security and privacy, which I think as well. I think technology gives us the ability to have both. Of course, depends how we would like to manage the different aspects. Basically, privacy and security are two sides of the same coin. Privacy, I would say, of people towards security of things. First is the ability of an individual or group to seclude themselves or information about themselves and thereby express themselves selectively. While security is the practice of protecting information by mitigating information risks. It involves, and Faith explained it very well during her presentation, preventing or reducing the probability of unauthorized or inappropriate access to data, or even though unlawful use of those data. And let's say that considering those definitions, privacy, data protections, and security are intricately linked to rights, freedom, and responsibility, and should be introduced to children from their very first steps on the internet. It's not a matter of adults, it's not a matter of deputies, it's not a matter of experts in cybersecurity, whatever. It's a matter of educating people from the younger age, let's say, over the internet. Users who are aware of the responsibility and challenge are basically more able to detect and to circumvent online risk and dangers. They are more able to protect their data and digital identity and maintain, let's say, security measures that make their digital activity safe and sustainable for themselves and others. When online, basically everyone is entitled to safety and security. security, as well as respect for the ideas they share and fair treatment for the resources they create and they disseminate. This is let's say, kind of a philosophical statement, I say by now. But the right of access is inevitably accompanied by expectations and responsibilities. And schools and families have an essential role in preparing also young people to show their needs. As technology progresses seamlessly into every corner of our daily life, privacy and protection are becoming inextricably entwined. Nowadays, internet security no longer only depends on how we, as digital citizens, manage our own security risk, but is also making sure that our action and behavior do not put others at risk. That's mainly the paradigm between privacy for people and security for let's say, the infrastructure they use and the software they are running different activities on. Being a digital citizen, therefore, means learning how to protect access to our devices and handle care anything that can threaten their privacy and security of ourselves or others. Educating is then the real responsibility of responsible stakeholders in the digital age and economy, and must be a priority if the internet is to be an environment of trust where basically fundamental human rights and civic mindedness prevail. Of course, I was about to quote Edward Snowden, who, let's say, famously said that arguing that you don't care about the right to privacy because you have nothing to hide is more or less really not different than saying you don't care about free speech because you have nothing to say. And it drives us to the challenge that privacy protection poses to our society and us as individuals. Basically, it forces us to change the corporate culture by, let's say, setting up and driving the path to more privacy by design, keeping personal data protection in mind whenever we create, we conceive, we develop, and we operate a new digital system by being, let's say, user-centric instead of being infrastructure-centric. To ensure effective collaboration between departments and teams, this is the famous example in the GDPR about the DPO. This is the role, principally, of the data protection officer. To also better allocate resources and budget to make it real. It's not only an idea, it's not only a philosophy, it's also something that we need to make it real, genuine, let's say. And finally, to understand the risk for the data subject. And so privacy faces also many challenges and threats due to its nature. Basically, I summarize them in four main challenges and threats, which are big data development by collecting, storing, and analyzing large volumes of data. The fast data transmission world we are living in due to constant improvement in networks and connections. The less and less restricted access to data worldwide due to performant network, and the larger and larger increase in data storage due to constant global communication via the internet. And this is the, let's say, what if topic, the what if paradigm. Let's say we are going to keep it, we never know, of course. And as we live in an age of big data, where private information is now kind of a currency, citizens everywhere, and not just children or young people, but keep in mind their online activities, especially in social media. And when using search engines, that may be the consumer, but they are also the product. You know, whenever it's free, you are the product, basically. And both commercial sites and non-commercial sites and platforms customize more and more the content they feed us based on profile that has been built from the footprints we have left online. Even national elections and referendums have purportedly been shaped through profiling voters and using big data in some unscrupulous ways. Remember the election of Mr. Trump 5 years ago, which led to a lot of controversies around Did the Russian have been involved in manipulating social networks, blah, 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 the scandal, the famous scandal of Cambridge Analytica, and so on. So all those stories, say all those affairs, remember that this is not of no importance. Although in today's world, it's an almost impossible feat for citizens to maintain full power of their over their personal data, education can go a long way by fostering at least the relevant skills. Understanding the terms and conditions of information service providers, for instance, the purpose of cookies before consenting to them are, let's say, essential in digital citizenship. Citizens must also be able to decide when to provide or not provide data that is being requested, verify the purpose of them, and use of data collection, make sure they know how collected information will be processed. They must know how, when, and where to accept that personal data is accessed, refuse this collection without informed consent, of course, have it corrected, basically, or delisted, or even erased. Citizens need to know, and it will be my word over that, how to contact service providers and seek recourse from the National Data Protection Authority in their country. You know that there are a lot of countries, 137 have a legislation right now, so you have at least those opportunities to contact them. Contacting, let's say, maybe a judge, depending on national legislation, or an advocacy group when they think their rights are being breached. Big data, of course, refers to a large amount of different type of data produced with high velocity from a high number of various type and resource. Basically, I won't go too much in depth in the concept of big data because this is not the purpose of this webinar. But basically, there are different factors that will drive the use of big data and their, let's say, attempt to violate potentially privacy of people because of their nature. First nature is aggregation. The size, the shape, and the structure of big data will create the willingness from the one using them to obtain more and more and more and vastly more data from the audience. The type of analysis, those data sets that are aggregated, the quantitative analysis software, they need to get fed a lot by a lot of information coming in there every day. And the recent shift we observed on the market from a retrospective to a predictive insight from the different actors in the field of advertisement and social relationships, social networks, drive also the path to some additional threat for the big data. And then the increasing value of the data itself, facilitating small but constant, fast and incremental business change, even for small business, being able to make a lot of value, a lot of money out of those, let's say, resources. And at the very end, the enhancement of competitiveness, efficiency, and innovation, and the value of the data so used is also some vector for that. You can see the evolution of worldwide data streams. So when we talk about 40,000, so from 10,000 to 40,000, it's terabytes per second. So which show the importance of those flows that are constantly flooding, let's say, from the subject to the advertisement company. And so those threats are real, and basically we can summarize them in 6 different categories. Leaks of data via web application because of unsecure APIs, denial of service, identity fraud, interception of information, inadequate design and planning or incorrect adaptation of software, and skill shortage on the side of the different editors, vendors, and so on. Big data risk for a company can also be considered in terms not only of privacy concerns for the employee or the client, but also as a risk in terms of security for themselves, driving to data compliance risk, risk on a national, international, or social level, data risk, data safety, and data quality risk, definition and statement risk, model development risk, or interpretation risk. Those different biases have to be, let's say, thoroughly evaluated and have to be correctly addressed before starting working on those type of things. Otherwise, the risk will be very, very important that those biases drive to a violation of privacy to some extent. And security of information systems have also kind of issues to tackle. And this is why there is some kind of, let's say, balance to find between the respect to privacy compared to the risk security threats posed to the market, posed to the companies, posed to the different stakeholders over the internet. Basically, I summarize them into uncover users' password, phishing, installation of malware, detection of codes by penetrating the system, so pen test, divulge confidential information, spam, phishing, smashing, mushing, whatever you can say, mulching, which is when you do that with the grass, and also other action that could be damageable for the information. And as we all know, information security's primary focus is, of course, the balanced protection of the confidentiality, integrity, and availability of data. And Fate explained it very well, of course, the CIA triad, the due to the respect of the properties of the different aspect of the security of the information, while keeping a focus on efficient policy implementation, all without hampering organization productivity and without hampering neither the privacy of the different subject. This is largely achieved through a structured risk management process that involves different aspects of identification of information, evaluation of risk, deciding on how to address or to treat those risks, to avoid, to mitigate, to share, or to accept them. Where risk mitigation is required, selecting or designing appropriate security controls and implementing them, and also, of course, also monitoring activities, adjusting as necessary to address any issues, change and improvement opportunities. And basically, one of the main issues is also to being able to standardize these disciplines. And for doing so, academics and professionals collaborate to offer guidance, policies, and industry standards on password, antivirus software, firewall, encryption software, legal liability, security awareness and training, and so forth. So this standardization may be further driven by a wide variety of laws and regulation, as we explained, that affect how data will be accessed, processed, stored, transferred, and potentially at the end of the life cycle destroyed. This is precisely what we have to ask ourselves when we plan to put in place a framework that will be, let's say, on one side respectful of privacy matters, and on the other hand, being able to be let's say, on the security perspective, efficient towards the threats that our assets face. Basically, this plan in 6 steps, this is steps for personal data management and the different driver, will ask us some questions. And those questions we need to ask ourselves anytime we are, let's say, facing a privacy concern, a potential privacy concerns raising from the situation, raising from a new project, raising from a new situational development we would like to put in place in order to sell better, in order to organize ourselves better, to collaborate better, and so on and so forth. I won't go, let's say, too much further in reading all the questions. You will have the chance, I guess, to observe those things and to read them out during the rewatch on YouTube. But anyhow, I've been taking one main and important principle out of that is privacy by design and privacy by default, so basically 2. And there are basically 7 principles to keeping, let's say, more efficient, the most effective possible towards those questions. the process must be proactive. The privacy by design approach is characterized by proactive rather than reactive measures. It anticipates and prevents privacy invasive events before they happen. Privacy by design does not wait for privacy risk to materialize, nor does it offer remedies for resolving privacy infractions when they have occurred. It aims better to prevent them from occurring. In short, let's say privacy by design come before the fact, not after. That's the first. Second principle, privacy as the default setting. Privacy by design seeks to deliver the maximum degree of privacy by ensuring that personal data are automatically protected in any given IT system or business practice. If an individual does nothing, their privacy still remains intact. No action should be required on the part of the individual to protect their privacy. It is built into the system by default. Let's say some example of them: cookies or parameters settings on social media network, for instance. You know, for instance, Facebook or Instagram or even WhatsApp, they recently changed their default settings, their default parameters for confidentiality and privacy. This is especially an attempt, let's say, to get like whiter on those concerns in order to be able to better protect or better respect, at least, the settings for their subject. Privacy embedded into design. The privacy by design is embedded into the design and the architecture of IT systems and business practice. It's not bolted on as an add-on. It's something that's really conceived at the time. The result of that is privacy becomes an essential component of the core functionality being delivered for real. And privacy is then integral to the system without diminishing functionality at all. Which is driving to my fourth point: full functionality. It's a positive sum, not zero sum. Privacy by design seeks to accommodate all legitimate interests and objectives in a positive sum, win-win manner, let's say, not through a dated zero-sum approach where unnecessary trade-offs are made. Instead of that, privacy by design avoids the pretense of, let's say, false dichotomies, such as privacy versus security. And it comes to the end of my presentation. There is no trade-off to look for. Basically, we can demonstrate by the privacy by design and by default approach that it is possible to have both. It's privileged as well end-to-end security. Privacy by design having been embedded into the system prior to the first element of information being collected, it extends securely throughout the entire life cycle of the data involved. Remember the table I presented the slide before. Strong security measures are essential to privacy from start to finish. This ensures that all data are securely retained and then securely destroyed at the end of the process in a timely fashion. Thus, privacy by design ensures cradle to grave secure lifecycle management of information on an end-to-end basis. Then we come to visibility and transparency. Privacy by design seeks to assure all stakeholders that whatever the business practice or technology involved, it is in fact operating according to the stated promises and objective. This is also subject to independent verification. Its component parts and operation remain visible and transparent to users and providers alike. Remember, trust, but verify. Then, respect for user privacy is the last one. Above all, privacy by design requires architects and operators to protect the interests of the individual by offering such measures as strong privacy defaults, appropriate notice, and empowering user-friendly options, which will come back to the principle I presented at the beginning of my presentation, which keep it user-centric. And then, of course, we can add extra layers of measures towards those principles of security by design and by default, which is the adequate countermeasures we commonly put in place, for instance, within ISMSs or cybersecurity programs or different other aspects. physical access control, logical access control, storage encryption, transfer encryption, malware protection, backup, BYD limitation and control, or even suppression in case it's necessary, control over USB ports, phones, laptop, and so on, secure ring network, and of course, because you know the issue is always between the screen and the chair, training and awareness are also very important. So this is my last word on that. I wish that presentation was interesting to you. I would like to thank you for attention, and I drive the word back to Pierre.
Thank you very much, Pierre, for this very interesting presentation. We'll proceed now with the questions and answers. We have already some of them, which have been shared by our participants. In any case, if you have any other questions, well, let's say, while I will present the questions to both of our panelists, just do not hesitate and, let's say, take the chance to ask these last questions. So the first question is coming from someone who is looking at us, who's called Dark Horse, who is asking Faith in particular. So basically, he's saying, in Kenya scene, do you also see DPO's role being enforced by the government like we've had with CVK roles regarding cyber assurance?
Hello, so thank you. Definitely, yes. In terms of the implementation, I think we can already see that there is some semblance of, seriousness around this matter, because number one, of course, apart from having the law passed, we had the Office of the Data Protection Commissioner set up, right, which is led by Commissioner Kasait. And so essentially that means that the office is in place and the regulation is active, and they even gave a deadline in July for organizations to go on and register either as processors or controllers. The other thing that they've done recently, actually this month also, is that they released a guidance note on the implementation or compliance with this particular act, right? And so in this guidance note, they've gone on to actually talk about what is the implication to organizations, say, for example, that are termed as those that are non-exempt. It's mandatory for you to register as a data processor or controller. The fees associated with it in terms of the size of the organization, number of employees, your turnover, and so on and so forth. And also to list down the specific implications of non-compliance. Also talking about the fact that even after you register, you get a license, it is active for a year and has to be renewed on an annual basis, and so on and so forth. And so indeed, I believe that there is indication that it is going to be implemented. I want to believe that, although comparing what we have done in Kenya, considering the fact that we enacted ours way earlier, I think early in 2019, compared to other countries like in Uganda, where already it's been, the law's already been published, right? Over and above that, the Office of Data Protection that is under NITA Uganda has gone ahead to ensure organizations register. So in fact, many organizations, especially financial institutions in Uganda, already registered, and the Office of Data Privacy in Uganda has already conducted initial assessments to organizations that have registered. So of course, I want to say that we are lagging behind, although I know that there is a deadline for registration, but I believe, or I want to hope that this will improve in at least for the rest of the year, that we will see the ODPC becoming serious and, taking a more proactive stance to ensure that organizations are going ahead to comply with this particular regulation, because I know if Kenyans are left to their devices, we'll always find a way to, navigate around something. And so I believe that, and especially this law, because it's very stressful in terms of achieving compliance, and the things that go into it requires the organization to be very methodical, to understand, and forces you to actually think about security and the controls therein, yeah? And so I really think that then the ODPC in this sense needs to be, more proactive towards ensuring that, it's implemented, starting with what happens to people who do not meet the deadline or the deadline, yeah, for registration.
Okay, great. Thank you. We have another question, which I think it's quite interesting as well, from Stella Simiu, who is asking, and I guess that for this one, it would be nice to have both of your perspective. She's asking on whether or not you think that if a DPO should have a legal background.
For who is the question?
You can go ahead.
Any of you, and I think that both of you could react to this one. I think it's quite.
Out of courtesy, I let Faith starting to answer. I will come back after.
Okay. Thank you, Pierre. So I think looking at the role of the DPO, right, there is, from the pool of qualified professionals, it comes from two main disciplines. So the first one is lawyers, people who have the legal background. And then now they transition into, because they understand the laws very well, then they transition into interpreting that law and ensuring that there's compliance. The other set of qualified individuals is ICT professionals, and especially those with a security background. Why? Because it becomes very easy for them to read and fully understand the law and then ensure its implementation. Okay. And so I really do not think that a DPO has to have a legal background. Of course, it has its own perks and advantages, because, and especially when you read most of these laws, they have a close relation with other laws, like it has a close relation with cybersecurity laws in the country and so on and so forth. So there is an advantage to that. However, also, again, when you look at IT professional or even a compliance professional who understands risk and security very well, would just need to understand the law very well, ensure that they've read it thorough, understand every other integrated law, and how to ensure compliance in their relevant organizations. So no, I don't think that a DPO has to have legal background per se.
Okay, great. Let's say from your perspective, Pierre, I know that you have a background in legal as well. So.
Basically, I do have. No, I'm quite okay with what Faith explained, and this is a question of being pragmatic as well. Mm-hmm. In many organizations, the main issue to tackle by privacy by design, for instance, or by applying principle, comes to some practical IT management as well. So I would say, although the legal background can be an asset at the very beginning of such an employment, it needs to be combined more or less, and sooner or later with IT strong skills as well, just in order to being able to identify the risk adequately, identifying the asset correctly, dealing also with the CISO, for instance. And it was a question when we started talking a lot about GDPR, the question raised a lot. Is it possible that the CISO holds the role of a DPO? Is it possible a DPO could become the CISO of the organization? Is it the same person, like Dr. Jekyll and Mr. Hyde? You know, those questions, they are since they are legitimate. I would say these are two faces of the same coins, like security and privacy, basically. So what I explained during my presentation could also be applicable to DPO and CISO. So the DPO can have a legal background. At least he must have an interest in legal matters and the ability to criticize, to connect the dots, and to being able to follow up on, let's say, the legal watch that is necessary for keeping efficient and keeping up to date in those matters. But basically, I would say, if I should hire a DPO in my organization, I would probably take someone with more a CISO profile and the ability to hold on legal, to take over on legal matters, instead of the contrary. That would be my point.
Perfect. Very interesting. So thank you very much. I think that's all the questions so far. So yeah, just let me double check. Looks like this. So
otherwise, if you would like to know if it was sympathetic for us, it was.
That's great. Thank you very much for joining, both of you. With this, I think that the only thing that is left is just to wish everyone a nice summer, which is coming and which is here.
You too. And to all the audience, of course.
Yeah. Thank you very much.
thank you very much, Faith, for coming. Hope we will have the joy to encounter later in fall.
Yeah, absolutely. Thank you. Thank you very much for having me. Thank you as well to the audience. It was really interesting, very good. Learned a lot. Thank you.
Thank you, Kirian, and thank you also to Asma, who is hidden behind the curtain, helping out for the technical aspects. So thank you very much to her and to Kirian.
You are very welcome. Good summer to all of you.
Thank you very much, Asma.
Bye-bye.
Thank you. Bye.
Bye.